All right, what we're doing here is we're reading a selected group of legal motions put forward by Schuyler Barbeau in his Second Amendment case to manufacture or to build his own machine gun with a short-barreled rifle. And as many of you know, pacer.gov is where you can download a lot of these files, and on any particular docket report there may be hundreds, if not thousands, of legal documents. And so Schuyler has selected a few of these docket numbers that, if we read them, we'll become acquainted with the arguments of his case. So we're going to move forward and read number 42. All right, this is United States of America versus Schuyler Pyatte Barbeau. Government's motion in limine. In limine means before the trial even begins. They just want to have this motion ruled upon before the trial even begins, regarding certain questions of law, dated July the 22nd, 2016. The United States of America by and through Annette L. Hayes, boo, United States Attorney for the Western District of Washington, and Thomas M. Woods, boo, Assistant United States Attorney for said district, respectfully moves in limine to preclude the defense from arguing certain questions of law about which the court has already ruled. Specifically, the government seeks an order precluding the defense from arguing at trial that Barbeau, 1, had a Second Amendment right to possess the firearm in question. They don't even want Schuyler to argue that he had a Second Amendment right. 2, had a legal justification to possess the firearm. 3, should be acquitted because he did not know it was illegal to possess an unregistered short-barreled rifle or machine gun. The firearm. On June the 5th, 2015, the FBI received information from a confidential human source. I forget his name. He got paid $3,500 to rat out his friend. Can't believe I can't remember his name now. But anyway, CHS regarding potential threats to law enforcement made by Schuyler Barbeau. The CHS advised that Barbeau frequently told the CHS that federal government was not abiding by its principles set forth in the Constitution, and that many public servants, such as judges and police officers who had sworn to uphold it, had deviated from their oath of office. Barbeau told the CHS that it was his duty to educate public servants who were not living up to their oath, and discussed lynching those he deemed unworthy if necessary. In one instance, Barbeau told the CHS that he and other like-minded individuals would physically remove a California judge presiding over a misdemeanor weapons violation he received there in the fall of 2014. The CHS advised Barbeau was always armed with a .45 caliber pistol and frequently traveled with a short-barreled rifle, a short-barreled AR-15 rifle, SBR, body armor, and a helmet in his vehicle. On October the 19th, 2015, Barbeau invited the CHS to a trailer he was occupying in Springdale, Washington, and discussed selling his SBR. Barbeau asked the CHS to find a buyer for him and allowed the CHS to take several photographs of the SBR. Barbeau informed the CHS that he willing to sell the SBR along with a longer barrel, optics, and other accessories for $5,000. On November the 3rd, 2015, Barbeau contacted the CHS via telephone with additional information about the sale of his SBR. During the telephone conversation, Barbeau informed the CHS that he wanted to use the money from the sale to purchase a rifle capable of firing 7.62 millimeter rounds. Barbeau believed this type of rifle would be more effective in shootouts with law enforcement. On November the 8th, 2015, the CHS met with the Barbeau and informed him that she had a buyer interested in purchasing his SBR for the $5,000 Barbeau had asked for previously. Barbeau told the CHS he would consider the offer. On November the 20th, 2015, Barbeau contacted the CHS via a private Facebook message and asked him to tell the buyer he was ready to sell his SBR as soon as possible. The CHS told Barbeau the buyer was out of town for the upcoming Thanksgiving holiday, but offered to keep the SBR until the buyer returned. Barbeau agreed to let the CHS keep the SBR and arranged to meet the CHS the afternoon of November the 22nd. On the morning of November the 22nd, 2015, Barbeau unexpectedly dropped off the SBR at CHS's residence in the Western District of Washington and asked him to obtain the money from the buyer as soon as possible. Shortly after, Barbeau departed the residence and the CHS contacted the FBI. Later that same morning, the FBI met with the CHS and took possession of the SPR. On December the 6th, 2015, Barbeau was arrested at the Snoqualmie Way Station. Barbeau was armed with a pistol. B. The auto seer. During the investigation, the CHS advised the FBI that Barbeau spoke on several occasions about manufacturing a drop-in auto seer for his rifle. A drop-in auto seer is a combination of parts designed and intended for use in converting a weapon to shoot automatically more than one shot without manual reloading by a single function of the trigger. Thus, an auto seer generally is considered a machine gun under federal law, and the use of an auto seer with a firearm generally transforms the firearm into a machine gun as defined by federal law. On November the 8th, 2015, Barbeau referenced shooting down a hypothetical law enforcement helicopter and spoke in vague terms regarding his rifle firing in fully automatic mode. According to a recording of the meeting, he stated, "Remember what I have on my rifle? It ain't no just pew, 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 pew." The CHS then asked Barbeau, "Did you get that thing to work?" Barbeau replied, "It works, but not good, but it works. And if I can ever find somebody with a 3D printer." Recent developments in 3D printing have allowed individuals the capability to manufacture firearm parts, including auto seers, using plans that are available on the internet. On November the 20th, 2015, the CHS advised the FBI that on the same day the CHS and Barbeau spoke on the telephone. This conversation was recorded. During the conversation, Barbeau and the CHS discussed new rifles and that Barbeau was interested in buying. The CHS asked Barbeau if the auto seer would work in the new guns being discussed. Barbeau responded, "Yeah." C. ATF's examination of the firearms. An ATF firearms specialist has examined the firearm that Barbeau gave to the CHS. The specialist has concluded that the firearm is a short-barreled rifle as well as a machine gun. The firearm constitutes a machine gun for two reasons. First, the firearm contained the auto seer device, which the specialist confirmed allowed the firearm to fire fully automatically. Second, the specialist observed that the firearm fired fully automatically even without the auto seer device. D. The charges. On February 25th, 2015, a grand jury returned a superseding indictment charging Barbeau with 1. Possessing an unregistered short-barreled rifle and a machine gun in violation of National Firearms Act 26 U.S.C. 5861D, 5845A3, 6, and 2. Unlawful possession of a machine gun in violation of Title 18 U.S.C. Code Section 9220. E. The previous court rulings. On February 23rd, 2016, the defense filed motion seeking 1. The dismissal of the indictment on the ground that Barbeau had a Second Amendment right to possess the firearm in question. 2. A jury instruction allowing the jury to find that Barbeau acted with legal necessity in possessing the firearm. 3. An order requiring the government to prove that Barbeau knew it was illegal to possess either a machine gun or a short-barreled rifle. Docket 24 through 26. On March the 16th, 2017, the court denied the motions in full. Docket 35. Specifically, the court held that 1. There is no Second Amendment right to possess either a machine gun or a short-barreled rifle. 2. Barbeau was not entitled to a legal justification jury instruction. 3. Barbeau was not entitled to an instruction requiring the government to prove that Barbeau knew it was illegal to possess either a machine gun or a short-barreled rifle. Docket 35. In light of this ruling, the government seeks an in limine ruling precluding the defendant from arguing to the jury that Barbeau 1. Had a Second Amendment right to possess the firearm in question, 2. Acted with legal necessity, and 3. Should be acquitted because he did not believe it was illegal to possess the firearm in question. These 3 points are all questions of law about which the court has already ruled and are the proper subject of a pretrial ruling curtailing the arguments that can be made to the jury. See generally United States versus Amparo. Court decides questions of law while jury decides questions of fact. Conclusion. For the foregoing reasons, the court should grant the government's motion in limine regarding the topics outlined above. This is also document number 42-1, United States of America versus Schuyler Pyatte Barbeau. This is the response from Judge Richard A. Jones. Proposed order granting government's motion in limine. Surprise, surprise, the government is granting the motion from the U.S. attorneys. Motion in limine regarding certain questions at law. The court, having considered the government's motion in limine, hereby rules that the defense is precluded at trial from arguing that Barbeau 1. Had a Second Amendment right to possess the firearm in question. There goes the Constitution. Acted with legal necessity. And 3. Should be acquitted because he did not believe it was illegal to possess a firearm in question. Dated this, and it's left blank, day of July 2016, Richard A. Jones. So what they're not allowing the Constitution in the courtroom, and they're also not allowing jury nullification in the courtroom. We'll get to the rest of these motions as we get time. We pray that you guys remember Schuyler Barbeau in your prayers and write him a letter. He's in prison. He's been in prison for over a year, and his trial is coming up on June the 5th. God bless every one of you.